The judge in the Virginia trial not only shot down a certain nameless person saying, "You can't get out of this trial," he said that the UK trial probably wasn't fair. That's right. He called out the UK trial. This stuff, it is a monster win. We're still going forward. Oh, fun times today. Fun times indeed. So hey there to all you fine folks on this fine day, by the way. I hope you are doing excellently. And today is a big one, a very, very big one. So share this around. Make sure everyone sees it. Stop right now. Like the video, comment, just say you're going to feed the algorithm, then start it up because you're going to love this here. So today we got the decision on trying to dismiss the case a third time. Guess what happened? We're still going forward. And not only that, I want to read you something here because you can see the judge putting on blast the idea that JD got a fair trial. I mean, listen to this here. The court is not persuaded by defendants. Again, remember, defendant, that's that certain nameless person. Argument that plaintiff, again, plaintiff is JD, had a full and fair opportunity to litigate the UK action. So that trial there might have not been fair. Let's see why. Defendant was not a party in the UK action and was not treated as one. That's what I said over and over again, by the way. You couldn't take them to task. You couldn't question what they did, and yet they treated it like they did. Because she was not a named defendant, she was not subject to the same discovery rules applicable in named parties. And then they get to the argument that this case, it was actually decided at the other place. In fact, defendant could not have been a named party in the UK litigation because her allegedly defamatory statements were made after the UK action commenced. So you didn't get a fair trial with that. You couldn't take her to task, and even if you wanted to stick to that argument there, well, it's kind of hard to do that when this is all about defamation. And the statements made in the Washington Post article, they didn't come up until after that trial had already started anyhow. Now, if you like that, it gets even better, because the judge in the Virginia trial says that the judge in the UK trial, Judge Nickel, said the disclosures by a third party could only be ordered when it helped the applicant or adversely affected one of the parties. The judge, however, he kept refusing JD's request when it came to a certain nameless person. Quote, Attachment 3 to the defendant's reply brief includes a ruling from the UK judge regarding whether defendants should be ordered to make certain third-party disclosures. So, it's talking about an attachment there saying whether or not that third party there, the nameless person, actually has to disclose certain things. Such third-party disclosures may be ordered only when the documents sought, these are the rules that were set down by the UK judge, by the way, are likely to support the case of the applicant or adversely affect the case of one of the parties, and disclosure is necessary in order to depose fairly of the claim. Thus, to argue plaintiff, again, plaintiff, that's JD, fully and fairly participated in the UK trial action because defendant, these are the defendant's own words, this is what the nameless person said, this is fair, this is how it breaks down, therefore, was an active participant providing evidence, 7 witness statements, and sitting for 4 days of live testimony is incongruous with the UK judge's ruling regarding defendants' discovery obligations. Specifically, the judge refused the claimant's application for a third-party disclosure order against that nameless person. So here the judge is saying that JD, he didn't get to fully and fairly participate in the UK trial action because he couldn't take that nameless person to task. When they were on the stand, everything they said, it was like it was gospel, and that's exactly how it was treated. You couldn't go in, you couldn't truly question what they provided. If you asked them a question and they said, yeah, that was true, then that's how it stood. And that's not justice at all. Now, the hits, they just keep coming for that nameless person, too, as the idea that the U.S. and the UK trials are the same, yeah, that is shot down fully. quote, defendant's claim of res judica, basically, has this been tried before, is especially puzzling. At the time plaintiff initiated his suit against the Sun, defendant has not even released her op-ed. Plaintiff's defamation claim in the UK was based on a completely different statement than the present case. The specific statements uttered in defamation cases, they are incredibly important. That's why this court, after defendant's demur, analyzed the 4 statements originally sued upon to determine if each statement met the requirements for defamation. The statements from the Sun and from defendants are not related in time. Several months passed between the publication of the 2 collective statements. They are not related in motivation. They are not related in space. The only relation is the origin, as both statements arose from plaintiff's alleged abuse. However, it would be nonsensical to find that any statement relating to whether plaintiff abused a defendant arose from the same transaction or occurrence simply because they came from the same origin. Therefore, given the lack of privity and the separate occurrences in question, res judica is inapplicable. Basically, trial is on, baby. You can't say because you had that other one that you've already had your shot. Then the judge absolutely demolishes the idea that everything is similar across the board by saying libel laws in Virginia, they're starkly different from those in England. Why? Declaration of Independence, First Amendment, United States Constitution, they represent major departures from the English common law with respect to freedom of speech and freedom of the press. In fact, England's overreaching suppression of freedom of speech during the 18th century drove the United States to regulate freedom of speech into a solid foundation of civil liberty. To hold that the 2 countries have similar libel laws is untenable. Not only are the substantive laws in the UK different than Virginia, but so too are the procedural laws. This is going through the idea that you have a right to jury. Here in Virginia, for example, they noting that in suits between persons, trial by jury is preferable to any other and ought to be held sacred. Now here's another act, finding that a party in a civil trial for fraud, malicious prosecution, or false imprisonment may request a jury trial. And here's yet another one, noting Parliament allowed civil trials for libel actions in the past, but now it is usual for defamation actions to be tried by a judge alone. In Virginia, plaintiffs are entitled to a trial by jury if so demanded. However, such rights are not available in the UK. Instead, in cases of libel, judgments are based on the reasoned decision of one judge as opposed to a bald verdict of a jury. So, you can't have that jury of your peers. You have one person decide. And yeah, you saw how that turned out, didn't you? Finally, you have this. Defendants claim that refusing to recognize the UK judgment in this case would set a dangerous precedent is unfounded. In fact, allegedly defamed parties are more likely to bring suit in England in general due to their more favorable defamation laws. So they name a lot of things here. If anything, upholding English libel judgments in the United States would create the chilling effect and could create a dangerous precedent. Accordingly, this court is unpersuaded by defendants' argument. So in closing, they say this: for the foregoing reasons, defendant's supplemental plea in bar is overruled. Regarding plaintiff's request for sanctions, such sanctions are denied. The defendant's supplemental plea in bar was misguided and only thinly supported by pre-existing law. It is not sanctionable. However, based on this opinion, paragraph 13 of defendant's ground of defense is hereby stricken as moot. An order is attacked. Yep, that judge wrecked every single notion that nameless person presented, owning them and then some, even going as far as to say that trial over there, doesn't look fair at all. But anyway, let me know what you think about that. As always, too, appreciate the heck out of you. You make this stuff work. Thank you. Want to help out the channel? Links in the description. Check those out. Always can use your help. You being here, though, that matters. So thank you. I appreciate you. We will see you soon.